Then? All right. We will call to order this Board of Equalization for Utah County, July 27th. Should I try talking? Definitely us.
Is it mine?
Well, I mean, that shouldn't matter. No, that one
How am I? Am I clear? So
How about now? All right, we're good. Okay.
Good.
Technology, first world problems, right? All right, we will call to order this meeting of the Board of Equalization for July 27th, 2023. We have Commissioners Sakovic and Powers Gardner in person, and Commissioner Gordon has joined us on Zoom. And we'll jump right into the agenda. We've got item number 1 is to approve meeting minutes.
I can motion to approve. I was not here by Zoom remotely or here physically, but I'm going over the minutes. I understand the context and I can approve the minutes as presented.
Second.
It's been moved and seconded. All in favor, say aye.
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 And it passes 3-0. I knew it passed, just didn't know by how much. We got item number 2, change some parcels from primary residential to secondary residential. Yeah, Bert, do you want to? Garfield, sorry, Harvey. Not Harvey, Garfield. You want to give us a really quick overview?
Per the owner's request, they want to be on secondary residential.
Okay, that's good enough for me.
I can motion to adopt Agenda 2 as presented.
Second.
It's been moved and seconded. All in favor, say aye.
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 That passes 3-0. Item number 3, approve or deny the reinstatement of the primary residential exemption for the parcels listed on the spreadsheet.
For my part, I've gone through them all and I have no questions on the content. And I'm able to approve. We're ready to do that.
Let's just ask.
So these are all people that were going to be on secondary, but in the since last time, they have proven that they are primary. So, and the documentation is all in your agenda with lease agreements and
Awesome.
evidence. So we're moving them from secondary to primary.
Okay.
Okay.
You good?
And I can
Make a motion to approve.
I can second a motion to
Great.
approve.
It's been moved and seconded. All in favor, say aye.
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 All right, that passes 3-0. Item number 4, approve or deny the application for review of the Board of Equalization of Urban Farming Assessment Act status for John D. Shepherd.
Good afternoon, board members. Ben Stanley with the County Attorney's Office representing the Utah County Assessor today. And the next 3 items on your agenda are Greenbelt or urban farming appeals that were denied by the County Assessor and the Farmland Assessment Analyst with the county. So this first one, John D. Shepherd, is a 5.47 acre parcel. To give you a little bit of quick history and a little bit of background, again, the assessor's office has a constitutional and statutory obligation to make sure that the taxing system is fair, and if a party or a parcel is not eligible for farmland assessment and that preferential tax treatment, we have an obligation to all the other taxpayers to deny those applications. This one came forward originally as a greenbelt request that was denied by the Farmland Assessment Analyst. The Board of Equalization instated the greenbelt status, so it was appealed by the assessor to the State Tax Commission. The State Tax Commission reversed the Board of Equalization, said it didn't qualify for greenbelt, but encouraged us to talk with them about urban farming because there was not the sufficient 5 acres in production. The applicant came back with an application to be on urban farming. That was denied because of the number of acres and the lack of production on acreage that was designated as the urban farm. So again, when there's a request for urban farming, there has to be a designation of the portion of the parcel that is being used for agricultural production. Here, the State Tax Commission in the Greenbelt hearing made some conclusions about the amount of space that was used for ingress and egress. If you look at the pictures, and maybe we can bring those up on the screen, what was submitted as assessor's documents. Again, the state law, yeah, perfect. We'll scroll through these in just a second. But state law is explicit that land associated with the home site, the residence, and associated with that residence are excluded from agricultural production. So here you have a number of photographs of kind of the parcel and the property. In the back end of the parcel, there is some space that could be used for agricultural production or for sheep or things like that. There's a significant portion of this property that is covered with slag and is used for moving vehicles in and out to both the house and to the back portion. And so under state law, we would exclude that from the measurement. And so what happened with this one is, yeah, keep going, this is great. So these are just some photographs that show what's used and how it's used. It shows sort of the volume of this slag area. If you scroll to kind of a overhead or an aerial view of this, I think towards the end we've got an aerial view. After those code citations, just keep going down a little further. Yeah, it's page 21 of the exhibit, so just keep going down. Oh.
Can you pull that up, Bert?
Look at the assessor document submission in the packet. With the agenda item number 4, there's assessor documents that have a number of photographs. The version that's in the agenda system has some code citations, and at the end of that, you can see at least a couple of aerial photographs.
In the appeal, at the very last page has an aerial photograph.
Yeah, it's just not on, Bert's gonna pull it up.
If you switch over to the Zoom view, yeah, there we go. If you switch over to the Zoom view, I'm sharing their document. Yeah, if you minimize that. There we go. Okay.
Yeah, page 21 is the start of those
Okay.
exhibits that show kind of an overhead of the parcel itself. Yeah, that's a good one to look at, just to kind of get a sense of where there could be agricultural production, where there can't be, where there's landscaping, and where there's just slag and asphalt and other surfaces that can't support agricultural production. So what happened in this case was the tax commission stated, even if we gave this the most generous view conceivably possible to the taxpayer, there couldn't be 5 acres. Even if we considered all that slag somehow agricultural production, it would be less than 5. Really, if you exclude that for the way that we measure it for urban farming, the designatable agricultural production should be maybe 3 or some 3.5 acres. That was not what was applied for. They asked for 4.7 or something like that. And the assessment analyst went to the parcel, and so did the assessor himself, and looked at this property. There's just not the production on a significant portion of it, and so the request was excessive.
What amount would you approve of it? 3.5, is that, do you agree with on that, Bert?
It's just a question of how much. We're fine with 3.5 acres.
Okay.
So in the application,
Can you bring this one up? This is at the bottom of the applicant's appeal.
applicant's arguments.
If it's the applicant's thing, then Bert Hardy has to.
From the applicant's application, is that what you're asking for?
Yes, it's the
Commissioner?
last page on their
All right.
application.
1 second. Let me share that for you.
Because the shaded areas, that's not appropriate in the other document, it shows that part of that livestock shed and corral is cut off as part of ag and part not. And then it has the corrals and grain silo. That's in support of the cattle. Is that not included in active production, storage of feed, hay, whatnot?
If land under a silo that's used for agricultural production is considered part of the agricultural production, I think there are some factual disputes between the assessor's office and the taxpayer over, whether fruit trees in that area are actually personal use or agricultural production,
Sure.
orchard style.
But if we
whether
don't, if we discount those, but just focus on the silo, the corral,
yeah,
livestock area.
and I think there's, again, there's no silo that they can see on the property there. There may be a dot drawn here and a label for a silo, but to the extent that they've been out and done their inspections, they don't see agricultural production in the areas that they haven't designated. So it's a question of, is there 3.5 acres that could be fairly designated as an urban farm, or is there more than that? In their site visits, their conclusion is 3.5 would be a reasonable amount to request. What was requested was denied, and the position of the assessor's office is that this appeal ought to be denied, and then let the applicant resubmit for a more reasonable amount of acreage and have that considered. But that's the assessor's point
You
of
said
view.
that 4.7 was what was requested, but you would feel comfortable with 3.5. Okay. Yeah, absolutely. We'll hear from him. Thank you.
So we're happy to give more information or answer questions, but yeah, I think it'd be appropriate to hear from the taxpayer at this point and then kind of let us address anything that needs to be addressed.
Thank you, Ben.
So I'm JD Shepherd. I own this parcel, but I guess mainly the question is the north side of my property. If that last, any of them aerial maps, I can maybe clarify
You want to pull one back?
everything.
No problem.
Thank you.
Maybe easier.
And can you do a side-by-side?
And I'm assuming that's the clarification is the north side.
Yeah, kind of around the house.
Okay, yeah. So, like you said, we went through all this with the Greenbelt Act, but when the judge sent the letter back, and I have it right here, it says. Let's see. So it says, although neither party raised Utah Code 592507, which governs exclusion of a farmhouse site from agricultural land, the commission finds its requirements determinative in this matter. Utah Code 592507 provides that land under barns, sheds, silos, cribs, greenhouses and like structures, lakes, dams, ponds, streams, and irrigation ditches and like facilities is included in determining the total area of land actively devoted to agricultural use. The pump house, branding pit, equipment shed, and the space required for the ingress and egress of these structures fit within the definition of the Utah Code 592507 and should thus be included in determining the total area of land actively devoted to agricultural use. The pump house supplies irrigation water to the farmland. However, no proffers were made as to its use for culinary water for the farmhouse and yard areas. While the branding pit could function as a fire pit for the family use, the taxpayer proffered and the county did not dispute that the only use of the branding pit was for the branding of livestock. The equipment shed was used for storage equipment used in agricultural operation. So that come from Judge Clinton Jensen. What he's referring to on that is it goes down farther, and he said 0.66 of an acre, including the slag covered driveway space, is a farmhouse site. So 0.66 of an acre is right on the bottom left of the screen there, our driveway going in, and it goes into our garage. He declared that residential along with our landscaping to the north would be to the north edge of our landscaping. That is pretty close to 0.66 of an acre. The rest of it he deemed could be used for agriculture. So That being said, the north side of our property, there is a silo standing. If I had a pointer, I could show you easier, but,
Where the blue dot is, or
well,
I don't see it otherwise.
it's hard. It's probably not on this aerial map, because this map's old.
Yeah.
But where it says,
Here, point on my screen here.
it's not right there.
Okay, so
There's
it's
there's
just to
trails.
the right of the blue dot.
So we have two trails right there, plus a silo standing, a grain silo.
Okay.
Which, I don't know how, no matter how you shake it, that's agriculture. That's what we use it for.
What's this?
Uh,
And why your line goes here instead of like there?
okay, that's another, that's for our sheepdog. That's a dog kennel. So,
Breed of sheepdog do you have?
what's that?
What breed of
Oh,
sheepdog?
border collie. Yep. So that's what that's used for. Sometimes we even put baby lambs in there. If they lose their mom, we put the doggy lambs in there where we can feed them easy. It's been used for that before. Back up to the north side. So there's a silo, there's two corrals along the edge, about 15 feet off of our landscaping is a row of peach trees that we planted, along with also along the back, along the other side, which I didn't include that as agriculture. I give you that part of it, and then across the front, there's cherry trees planted. And our intent, they're small trees now, so they're not producing anything. They'll be a few years before they produce fruit. But our plan with that is to sell fruit to either the farmer's market, or I have two neighbors that sell fruit that is an option for me as well.
How many cherry trees?
There's just two cherry trees up front, and there's probably 7 apple trees, I think, planted, and maybe 8 or 9, 10 peach trees planted on either side. So our intent on that is to sell the fruit off of it, but that's, like I said, that's not going to happen until they're mature. So.
Yeah, and at this junction, we can only consider what's actively being done now. So that I think the cherry trees won't be able to be, or other fruit trees couldn't be considered on today's review, but what we're actually doing to produce agriculture is what the focus is for today.
But so if you plant any crop, it's no good until it's ready to harvest?
You have to have some production first to validate its ag use.
But I've heard Diane say before in other meetings that there's a grace period for the trees to grow, right?
Or for the crop to grow?
For the crop to grow, that's saying any orchard.
So what part of this does the assessor's office not agree with?
So we agree with the back pasture, though it doesn't really appear to be managed well.
Just a reminder, you need to come to the mic or it won't be on the record.
Thank you.
Diane Garcia, Utah County Assessor's Office. We agree with that back, what he refers to as the back pasture area. And then the sheep pens that are along the side there, we believe that, and it actually is a little bit more than 3.5, it's like 3.6, I think, when I measured it. We believe that is a for sure solid in agriculture production and has been for the past 2 years. So our criteria when anyone applies for urban farming, they have to show that it has been in production for the past 2 years. And so that would be the solid stuff. Some of the other stuff is not covered in urban farming, and or has not been established for 2 years.
Okay, so you don't necessarily disagree with the map. It's that there's areas that either A, aren't covered by urban farming, or B, have not been in production for 2 years. Is that
Correct.
correct? So for example, if we split the baby this year, he could apply for a greater section next year because you have to, you have to do
He has
this
to apply every year.
Yeah, he has to
correct.
apply every year. So as those get 2 years of production, he can
Right,
broaden that.
right. And he could greatly improve his acreage for urban farming as he, changes his production or increases his production or
So
whatever.
What part to change though? That's not. As I look, it says ditches and like structures are included. Is that correct? So why is that ditch going right through the center of that north side of that not included?
Yeah.
That's a piped drain for my sheep. How can that's a like structure, a water structure. So why is that? How is that not included?
That's a good.
So when it includes ponds and ditches, that is because they're open and you can't, grow a crop on top of a ditch or on top of a pond. But when it's piped under the ground, like a lot of farmers have a lot of irrigation piped under or even drainage ditches piped under, you can produce things on top of the soil. So that's why that was not included, because there's no agricultural production occurring over that pipe, and it could have production. They chose to fill that whole area in with that slag instead of having it, being in production. So that was a choice. So they can choose to change that or alter that or increase their agricultural production. That's what I'm saying. So it can change from year to year for urban farming as far as what they want to improve or.
But
Well, what are our options on splitting the baby?
Well, you have, you make the final determination on the factual side of things. So it's up to the Board of Equalization to decide which of this property is in agricultural use. It's up to you. You don't have the choice to include it if it's not in ag production. So
Right.
you don't have that kind of discretion, but you do have the discretion to decide,
And that's what I mean. Like, if
yeah,
we
is the
said we
doghouse
think-
part of the farming? That's your
Right.
decision. Same with the other items discussed.
Yeah.
The BOE needs to make the final decision. It sounds like somewhere between 3.5 or the 4.7. That's up to the Board of Equalization
Okay.
to decide. As long as you can decide that it's actually in ag use.
Yeah.
now, didn't he get a determination from the state that access to and egress
Egress and ingress, yeah.
was part of that? So that would include water flow,
Could.
in my interpretation of this.
Can I say
I'm
one more
not-
thing about
Yeah.
that pipe? You say it can be, do you know how deep that pipe is? Who knows how deep that pipe is? I do.
I would love to know. Would you?
It's like 1.5 feet deep. So when I sink a plow into the ground right there, what's gonna happen? It's gonna hit the pipe. So we can't till the ground if there's a shallow pipe right there. It make no sense to do that.
How many water shares do you have?
There's probably 5 shares of strawberry water and a handful of lakeshore irrigation river shares too.
Amelia?
Yeah.
I talked to JD about a month ago at Lake Shore Days about this, and then I understand Commissioner Sakovic or Lisa or Combined has been out there as well. Is that true, Tom?
Lisa has been for me, yes.
Yeah, okay. That's what I was thinking. I'd like to know your thinking last year when you approved it as Greenbelt before it got, does that make sense, my question?
Yep. Yeah.
Because as commissioners, it was approved as Greenbelt. I mean, I think you foresaw this as being, legitimately in agriculture. Is that accurate?
Yeah,
Yes,
I think
yeah.
the area that we included that isn't being included in this under the judge's ruling, under the appeal, was basically the ingress and egress on the south side of the property. So I think that that's what brought it under the 5 acres, where I think we had interpreted that as access to the ag building for the livestock and equipment, and we had interpreted that as ag area, which is why that was our thinking. But, yeah, and obviously this is a more, this drawing shows more of what the appeal from the State Tax Commission said.
If I could speak to that. for
Gotcha.
just a second. Just to kind of clarify, on the State Tax Commission's appeal order provided what we call in legal parlance dicta. It didn't specifically say this is out, this is in. State law is not explicit on ingress and egress. The context and the full language of the order basically said if we gave everything in the favor of the taxpayer and looked at it, assuming anything that was even debatable was in agricultural production, there still would never be 5 acres, and so it wasn't eligible for the green belt. The assessor's position is that when we're looking at green belt, we do give a little bit of ingress and egress that's necessary to get farm equipment to a back pasture, for example. When we look at urban farming, we tend to look at what is the dedicated, designated part that's actually in agricultural production, and we're not as generous with ingress and egress. But either way, in this particular parcel, the assessor's office saw the amount of ingress and egress intended to be considered production as excessive. And so I guess my
Because of the
caution is
difference between greenbelt and urban farming.
partially that, yes, and partially just the fact that there was so much slag all around the home covering, the full width of the parcel that it was not necessary to consider all of that as legitimately essential to get equipment to the back end of the parcel. So even if it were in greenbelt, we wouldn't have granted, the assessor's office would not have considered all of that agricultural production. Again, state law doesn't define, and the standards of practice don't specifically speak to ingress and egress, but the practice within the assessor's office is to be willing to give some reasonable amount in a greenbelt context.
Right. Well, and I look at it and it's like the slag keeps the weeds down. If the area is not wide enough to actually use productively as a pasture, if it's not wide enough to use as a pasture, and it sounds like you've got about enough water shares to cover the back half and your animals, but not enough for the entire
I don't
parcel.
water that whole thing.
But where the slag is, I mean, what's your reasoning on having that much of it out of production in slag on the north side?
Well, the main reason is that front half doesn't grow anything. That's why we first took it out. But that's one reason. The other reason is you got to have an access to get semis in and out back there. So that takes a pretty wide radius to turn a semi into there and get it turned around to unload hay, grain, whatever you're unloading, sheep, whatever you're taking in and out of there. You got to have a pretty good ingress and egress. That north side of the property is right next to just left of the long shed row. That's where we back semis in. That's our loading chute. So you have to go in and turn around, go back out the north side, and then back into the chute right there. So it takes that much room. We're not talking small tractors and trucks. They're big. They take a lot of room.
How many head of sheep do you have?
My family has probably 400 to 500 head of ewes.
How many on this parcel?
On this parcel right now, there's probably 30 head right there right now.
Normally we're talking about production, right? And I don't think this is a lack of production. I think I've known him all my life and know that there's production happening, from the Shepherd family. So I think, Amelia, to your point earlier, about really getting to the number of square footage, I think that's that acreage number, right?
Yeah.
Is that what I'm hearing from you?
Yes. Yeah. I mean, so basically, I don't think anyone disputes that you've got production and that at least a portion of your parcel should be in the urban farming. But it doesn't do anybody good if we give you a big number and you have to go back to the State Tax Commission again and do this whole thing over again. And so what I'm trying to look at is a reasonable number that the State Tax Commission will accept, right? And that's why I look at it. I mean, you say you have 30 head on the property now. What's the max you ever have?
Oh, we've had probably 50, 60 head, or maybe even more. I mean, it changes all the time, but yeah, that's
So, and that's kind of what
Pretty
I'm
much
looking
what's
at.
there
It's
right
like, okay, well, the state tax commission has said we can't get you 5 acres, right?
yeah.
So once again, it doesn't do anybody any good if we go back and say, okay, well, we want to approve it 4.7 acres then for urban farming. If it gets appealed
I guess-
and you go to the tax commission, then I don't want you back here again. So I'm trying to look
lost on
for.
is I get told, well, you haven't had that stuff there for 2 years. Well, that silo I can move. It goes there. It goes, if I need to move it over here closer to where we're feeding, I can move it there. That whole area gets used for agriculture one way or another. So, and then as far as the ingress and egress, to me, you got to grant me some room to take a semi in and out of there.
So I haven't been on the property. Commissioner Gordon, it sounds like you have been on the property. What are your thoughts?
Yeah, that's why I'm just so, it's unique because he does have bigger trucks than a normal horse and truck trailer. They have semis that they use for their sheep, and always have. So
Yeah, and I never used semis for my sheep. We always used a trailer that we hauled behind our truck.
and
So
trailers.
And a couple of larger
Yeah, pickup
farms that I've
truck.
seen that needs semis to come and go, some more frequently than others. They've had this wide span of road access, and so that I can see why there's that much space if you have semis coming in on a fairly regular basis.
yeah,
even
we
if it's-
always had a 1-ton with a flatbed or a cage, right? So
Yeah.
I don't have a frame of reference.
So look at the pictures by both the assessor and the owner. I don't see anything unusual that we should not grant what he's asking for in this appeal here.
Now, I've always said I want to have consistency. I don't want to trip up on what we, do. And so being consistent with that in mind, I mean, I've heard two numbers. He applied for 4.7. The assessor's office said a different, they were more comfortable with 3.5. I mean, if now with the debate of the ingress and that area, I mean, is it unreasonable to say, to be somewhere between 4 and 4.25? I don't know.
The overlay that we had on the previous slide, not this one. Do you have that one? We can go off memory off of this one. If you can bring it up side by side, be better. Yeah, that one. There you go. Oh, that one there, yeah. The one in purple, does that represent what we believe is residential?
That just shows the soil survey.
Soil survey only, nothing that has to do with residential or agriculture production?
No.
Okay. Never mind then. I won't go to that one.
Well,
So the one,
I'm willing to default to Commissioner Gordon since he's actually seen the property and I have not. If you feel comfortable for a motion or if you have more questions.
When were you there last, Brendan?
It's been a minute. It's been a while.
The photographs, they look pretty much the same as when you last were there.
Yeah. Yep.
Garfield wants to make a comment.
Can we go back to the photos from the assessor's office?
Which one would you like?
Which one are you not, Bert? I appreciate you going out there as well.
Yeah, so I went out there. This is Bert Garfield.
Yeah.
And I took these photos. I'm trying to get to them. So these are photos I took. Can you go to the top? So
Just tell me when to stop.
Who's just doing? That right there. That's probably out of order. That's inside of the large, what would you call that?
Just, yeah, or
Ag building.
Shop, the large shop. Okay, go
Equipment
down.
shop? Is it equipment barn or shop, I mean?
We use it for equipment, and in the wintertime, we'll bring ewes and lambs in there.
Yeah. And then go down a little bit. So that's outside the shop.
So that's looking from the north.
Yeah. And then go down. That's a picture of where the sheep. How many? I didn't see 30 sheep there. How many sheep were there? They're all hiding behind
They're
this.
all behind the shed when you was there.
Yeah, when they're hiding from the, they're in the shade up behind the.
They were hiding from you.
Yeah.
Yeah,
They were like,
there's probably
hurry,
30.
Bert's coming. Hide behind the shed.
It's usually what people do. Even animals know that. So, but anyway, I was there. I'm pretty supportive of what our analyst has said. I think with urban farming, I think the emphasis on what's actually producing, and there's no debate. We're not debating that back section or where the sheep are. That's,
Well, and I could see like this area not being an ag production. That's kind of what I was wondering, like, if this went here, but if he's got silos and stuff here now, like, I could see this being bigger, and that's why I was saying split the baby. Because I could
Well,
see that
that's-
being
and
more,
like-
but I
That's
also
all I'm
think there
asking
needs-
for is what you just pointed out.
and that's kind of what Ben's saying is,
Like,
it's
we have
unclear.
to allow some ingress and egress. Like, for us to not allow any way for their vehicle to get there,
Okay. Okay.
and that's what I'm wondering, like, if, like, do you have a map like
Does that pasture really
this?
require semi-trucks to have access to it? Is that a small pasture? It's not even 2 acres. It's not,
So you say that, but if I got a load of sheep and I got to unload them in there, then
yeah.
what do you want me to do? Put them on a small truck to bring them into my yard?
Show me some of the other pictures I
That don't
took.
make sense.
So if you go
And
down.
that's why I'm saying, like, I think you're both, I mean, I see both your points, and that's why I'm like, can we split the
go
baby
further.
somehow where
That's
it's
the
like,
picture of the back pasture, down. That's
right, but if
the
he hauls the sheep there in a semi, like,
yeah. Yeah.
Yeah, not only sheep, but loads of hay that got to go in and out of there on semis. There's more than just sheep. There's, I mean, we farm 250, 300 acres, so it's more than just, we have more than just 30, 40 head of sheep that, I mean,
But
it's
that's
a
just
bigger
what you bring to
operation
your
than just
property?
that part.
how do you choose which ones you bring to your property?
Well, them are part of the using that are gonna have lambs. We lamb them there. This year we didn't lamb all. I got 3 brothers that all have sheep too, so we kind of divide and conquer to where they go. And anyways,
So you use it mostly for the lambing.
well, not necessarily. Right now, there's a herd of sheep there that are the dries.
Oh, okay.
So, yeah, but in the wintertime, for sure, lambing, it's a nice facility to lamb. It's dry in that big shed, and it's a good place to do that. But, yeah. But I kind of stuck on, there's krails there.
Mm-hmm.
There's a silo there. And there's a place to back a truck in, a semi, and there's got to be a wide, long area to get straight to back a truck in, which would be the ingress and egress.
Right.
On top of, there's a pipe that goes right through the middle of
Now,
it.
if
that's
this was
irrigation.
If this was a standalone operation, then I can totally see being like, you don't need semis. But looking at this as part of a larger operation, but looking at it separately, like, it's kind of ridiculous for us to expect them to like unload their sheep from semis or their hay from semis and put it on a smaller truck just to access this property. Like, if that's the equipment that they're using, that's the equipment that they're using. Like, when on my property this size, I would, and you know, running 20 to 30 sheep, that's what I had. I wasn't using semis, but I didn't have any other operation that I worked with it.
That brings up a good question. Is part of urban farming a consideration what they're doing on other parcels?
Well, it's what they're doing on that parcel, but that includes a semi.
Yeah. But is that, so I don't know. I'm not answering that.
Well, I think the question is, I mean, this is new territory for us, right? This is
new
the
territory.
first year.
But to be honest, I wouldn't mind if we did take this to the state so we can get clarification because we need to press this issue so we really
Right.
know what's ingress, what really do we need to say.
Right. And so I can totally, that's what I'm saying. I can totally see both sides of
This
this
is
argument.
uncharted territory.
Where it's totally uncharted and I can see like, I didn't use
see his
semis. Yeah. Thanks, JD. We appreciate you helping us figure this out.
You're gonna be the guinea pig for us. And then you can
I didn't
come
use
back
semis
and-
on my property that size. I had almost the exact same number of sheep you have. I had a little bit more property, I had more water shares, but I wasn't using semis, but I didn't have access to semis, right? I wasn't going to go rent one. I had a 1 ton.
Wait, you were a farmer?
Well, I wasn't a real farmer,
Amelia?
Commissioner Gordon. I was just a hobby farmer. I only had like 30 head of sheep and 42 trees. I only did like 2,500 pounds of cherries.
Okay, well, I won't go to there.
Anyway, that's our point. You guys can take it from here.
Would you go back to the other aerial view, Bert? And so let's wrap this up, I think. So I think we probably should not include fruit trees because we don't have 2 years worth of production yet. But I don't have a problem with the rest of the property.
Right, that's why I'm wondering if we,
So how do we
How old are the trees again?
identify the acreage amount? Can you
what if
do
we
that?
just said residential was 1 acre? Residential was 1 acre and take 0.3 off and then it's like ag is 4.4. Because then we're kind of cutting off a little bit around the edges where the fruit trees are.
Right.
That's why I'm saying.
Yeah.
I would feel totally comfortable doing that,
Yeah.
saying 1 acre is residential and 4.4 acres is
Yeah.
farming. And then if we need to, we can let the state tax commission tell us how much ingress and egress they get on urban farming as opposed to greenbelt.
Yeah. I'm good with that. That would be.
The only
fine.
question I have to that is why wouldn't we then just ask for the 4 point? What
Totally
he's
could.
asking if
I'm fine either way. I mean, like I said, I'm willing to do whatever.
I'm gonna say because if
and then like Bert says, we get some clarity.
if we're going to still contest this, maybe we should approve as is and let the final arbiter be at the state.
Does
That's
the
what I
state
was
change
at.
the
So-
amount or would they just come back and be like, no, too much?
It's a little tricky
how
in
does this
urban
work?
farming because we have to have a legal description of the designated portion for the farm. It's why it's hard to even make edits here on the amount because the assessor's office uses a legal description of the designated farming area to impose the lien and other things in the process of the application. The state presumably could say, well, this is going to be included, that's going to be excluded if the silo is mobile and can be relocated. Different things they'll look at and consider a whole host of issues. I don't know exactly how it's probably fairly novel territory for them too. I don't know exactly how they would handle it, but one of the concerns that we have in the assessor's office is how we impose the lien and how we have a legal description. So keep that in mind.
Okay.
Well, with that, given the back and forth, I'm happy to approve the application and see what happens next.
Yeah, I can second that.
All right, it's moved and seconded that we approve this application, and all in favor say aye.
Aye. JD, I would just suggest you have pictures.
Commissioner Gordon, are you gonna
of
vote?
Mobility of that silo.
you say
Just
aye?
have those pictures that shows where it's been moved, just to have that.
It's permanent there.
Yes, I did.
Oh, it's permanent now.
Passes 3-0.
Yeah,
Built there, it's just moved.
got it. All right.
All right, number 5, approve or deny application for review by Board of Equalization of the Farmland Assessment Act for Lynn and Diane Leifson. Are they here? Okay, Ben will present first, and then we'll have you come up.
Good afternoon again, board members. This parcel was applied for Greenbelt. It's a 3.81 acre parcel. The state law is very limited in the number of ways you can get less than 5 acres into greenbelt. There has to be a bona fide range improvement program. There's got to be a indispensable contribution to another parcel that is doing agricultural. So to get less than 5 acres in is limited in the options. If we look at the photographs on this one, the applicant is arguing that there's a crop rotation, which is why there has been no production during the periods of time when the assessor's office has been inspecting this property. And they're alleging that it's used in conjunction with another agricultural parcel, and so it needs to be put on greenbelt. The assessor's office fundamentally disagrees with that. If we look at the assessor's images,
Excuse me, I'm sorry to interrupt, but the question I have to point out at this point, with the pictures being displayed that way, are they being displayed so the participants on Zoom can view the pictures, or is those only being able to be viewed here in the meeting?
I've seen them before, but I cannot see them right now.
Okay,
that's helpful to know, and it may be better to have you, Bert, if you don't mind.
I'm happy. I just wanted to make sure that all participants can see the pictures, not just the room.
Yeah, that's better. I mean, it should be in the packet as well. And so, Commissioner Gordon, if you have access to the agenda system where you are, I'm actually looking at the assessor's documents that were submitted. If you can pull up that packet of information. So maybe the next tab over. I think these are the applicant's images.
No, those are mine.
Oh, are those yours? Okay, I guess I'm interested in the ones that are in the next tab over anyway, though, were the ones I was hoping to kind of talk a little bit about. Yeah, scroll down to the pictures lower in this file. Some of these pictures kind of capture the overhead of the parcel here that's under appeal that was denied greenbelt status by the assessor's office. One of the things I want to point out is this path that was carved in the earth on the kind of edge of that property to allow access to get down to a garage that's built down there between the house and that garage. Again, state law is explicit that property that is used in conjunction with the residence is excluded from agricultural production. If we scroll further through these pictures, you can see in the next one, Bert, there's the image of the little garage or whatever that is, 5-bay garage or something that was built there. I guess maybe we do need to look at that other set of images to see the kind of what's in that garage. So if you want to open up the next one now, go to that next tab, and I guess the 4-bay garage there. If you scroll down to the bottom of that one, you may be able to see some images of what's stored in there, the kayaks and off-road vehicles and stuff. It's in the assessor's view used in conjunction with the residence, not in conjunction with agricultural production, and it's not indispensable to the agricultural production for some other parcel, even though they do have one piece of farming equipment that's also stored in that garage. It looks like its primary purpose and intent is to be used in conjunction with the residence, and that driveway that was built, that path to kind of get access to this recreational equipment, we see as the primary purpose of this rather than any agricultural production. So from the assessor's view, they looked at that. They didn't see it as indispensable to some other agricultural production. You can't just put a tractor on your 4 acres over here since you have 6 acres somewhere else and try to get this also put on greenbelt. They denied it. That would be the recommendation from the assessor's office with this application as well. Happy to answer any questions. The other piece of this one that they've argued for is that there's no production on this parcel because of some kind of crop rotation. And it is the case that sometimes bona fide farmers will leave land fallow to help it prepare, but the state tax commission tells us that 99% of the time that's done through a government program of crop rotation, and there's lots of documentation to support that position. In those limited cases where there's not, there still should be a lot of documentation to explain what the rotation plan is, and we haven't had any of that produced by the applicant here. So from the assessor's position, and the proffered testimony. In the interest of time, we won't get into all the details, but we are recommending that it be denied.
Good afternoon. My name is Lynn Leifson. I've applied for this exception, if you will. The pictures and everything that you've looked at, I certainly cannot dispute or deny. That is what it is. Just a little bit of background with that. And I don't know exactly what you've had access to, if you've been able to look at the entire packet that, so you have seen that. One change I would make to that was that with the application, there's a drop-down menu that has Class 3 dry land, Class 4 dry land. Well, I clicked on Class 3, but it's actually more like Class 4. If you need any more information on that, you can look it up or take a look. I've made some copies of that so that you can look at it.
Thank you.
What this property is a hillside. You can see where there's steeper portions of it. Down at the bottom along River Bottoms Road, it is flatter, and it has been in production in the past. There's been, we've talked a lot about sheep. There's been an individual that's wanted to put some sheep in there in the spring when the grass is green. He's been able to do that. However, in the last couple of years, he has sold his sheep. He's not as young as he used to be, so he hasn't utilized that for grazing. The lower portion that you can see there, I have not had that in production the last little while because of the construction of the barn there. You saw pictures of that. Within that barn are pieces of my farm equipment. Around back, there's a lean-to shed there. You saw my swather, cultivator, and those pieces of equipment there. I use that in conjunction with another piece of ground that I have. It's 11.5 acres that's down the lane there about a quarter of a mile. During the construction of that barn, it turned out to be more of a marathon than a sprint. It took a long time, and I'm still working on getting that back into production as much as I can. You saw some pictures there. A son of mine likes to leave his side-by-side in there during the winter. You also saw the trailer that I used to haul hay. He threw his kayaks on there during the winter. So I don't agree with what was stated that is strictly in support of residential. However, you saw some pictures there. Within the barn is my tractor, my sprayer, my disc, my what's called a gopher getter, all of these things that I use for my farm operation. And so this is needed in conjunction with that farm operation. As I look at the requirements of the Farm Assessment, Utah Farmland Assessment Act, I feel that I comply with all of those. The application was made for Greenbelt, and that was denied on the basis of production. Now, that's an interesting thing because the hillside that you can see there has been in production. It's been used for grazing of sheep. We've talked a lot about sheep from the shepherds and what they've done with their sheep. The individual that's used that to graze that hillside off is, as I mentioned, Wayne Stone. He has some sheep just down the lane there. He's sold most of his sheep, and so he hasn't been using that for grazing. The flatter portion down there, a lot of that's hasn't been used in the last year or two because of the construction of that barn. But the property is less than 5 acres, and it's devoted to agriculture. There's a reasonable expectation of profit. However, I haven't seen that during the course of construction. And it was denied initially because of production. And the reason for that is, as I stated, the construction of that barn there. And the production requirement, again, I'm reading from the pamphlet here, the production requirement will be waived if the land is involved in a bona fide range improvement program or a crop rotation program or other similarly accepted agricultural practice, which does not give reasonable opportunity to satisfy the production level. The second page of what I showed you there, that handout I gave you, is you can look at it there. Intermountain farmers have been there. They have a particular dry land seed that's a dry land pasture seed. And what I'm going to do, based on their recommendation, is wait until this fall when the construction is done now, and I'll get that seed that they're recommending, plant that, and hopefully even as a dry land application, I can get all of that or most of that property back into production. But during the construction of that property, it's there's been egress and a lot of the construction equipment has had to come in and out of there. And so it's been difficult to have any type of production with that, any type of tillage, if you will, any type of planting. They recommend I wait until the fall, which I'm planning on doing that this fall. The other thing that's unique about this particular property, as I mentioned, it turned out to be a marathon and not a sprint. Before I could even get a building permit, the Utah County Community Development Department, or whatever they're called, required me to sign and record a document that indicates that's only used for agricultural purposes. And I've got a copy of it. There should be a copy of that with the packet if you've looked at that. I had to get that recorded. It's called a Notice of Agricultural Use and Restriction, which in essence means that can only be used for agricultural purposes, cannot be used for anything else. So I needed to do that to satisfy the requirement of the county, which I did. And
Did you
then,
charge your son for putting his kayaks on your trailer?
Pardon me?
Wondering if you charged your son for putting his kayaks on your trailer.
Absolutely not. I didn't charge him to park his side-by-side in there either. There was room, so he put his side-by-side and his kayaks in there.
There's a website, neighbor.com. You can charge him for square footage in your garage. Just kidding.
Well, I'm not going to do that with my son.
I'm teasing. Do you have a structure on your 11 acres?
No, I do not. So if I
So there's no
built this-
garage, there's no lean-to, there's no structure on the 11
No,
acres?
none at all. That's why I built this on that less productive ground. I do not have any irrigation water on that property, so it's got to be dry land. So if I would have built that particular barn on my other property, I would have had to take some of that out of production.
Is that property fenced? Is it fenced?
Only along River Bottoms Road, and then the portion that you see out over in that corner, the gas company owns that. They've put a chain link fence around that. The rest of it is not fenced.
When you grazed it to the neighbor, how did they graze on it with no fence?
Some electric fence,
They did electric fencing, okay.
yeah. And I'm not going to buy a herd of sheep and a bunch of electric fence just to graze off that property. And like I say, he's quit doing that the last couple of years. He's sold most of his sheep. So no, I have not grazed that off in the last last couple of years.
What other equipment do you have that is stored beyond the tractor?
If you wanted to look at those pictures again, as I mentioned, the tractor, the disc, the gopher,
Those four
poison
pieces?
applicator,
The implements, yeah.
the sprayer, and the lean-to on the back is the my spring tooth, swather, an old sickle mower, and a side delivery rake. So those are the pieces of equipment that I have. I've also got an old backhoe that has a fork on it that's used to load hay, and so that's the equipment that I keep there.
So if it's not parked here on a normal basis, where are they parked?
At my home or out near the farm.
Okay.
A neighbor of mine's got an area there where I'm able to park it.
How far is this from your other piece of property?
About a quarter of a mile.
Okay, so you can road. Do you just road the equipment down there, or do you haul it?
Yes.
You just road it
Yeah.
down there?
Down at the very bottom of that, you can see it's called Swenson Lane. It goes down to my property.
Okay, so if you're not going to fence it and graze it, how would you justify the rest of that property being considered in production? I mean, just because there's dry seed growing on it doesn't necessarily mean it's in production. I mean, I can see the garage being production where you store your equipment, and especially if there's no structure on your other property. But the rest of this, like on the hill slope and all those other areas, is there, I mean, if you don't have sheep and you're not grazing it and you're not getting fence, it doesn't seem like that's in production, other than just the bottom part.
If somebody comes along and wants to put up an electric fence and put their sheep there, I would welcome it.
Yeah, because at this point, the only I can maybe consider would be the actual 4-bay garage at this point, and access and egress out of that area. Because the rest of it, if it's not contained and it's not used, occasionally by sheep, but if on a regular basis it's not used, I don't think we can consider that as part of a urban farmland assessment. That's my difficulty with this.
Hey,
Yep.
Yeah, I know that area pretty well.
Commissioner Gordon, you're good to go. What do you have to say?
Okay. Yeah, I've been out there. Lynn's a friend of mine as well, neighbor. Son's one of my best friends, and then I shouldn't say this because but his brother was former Mayor Lason, so that doesn't help him, I know. But just so you guys know, I went out and met with Lynn and looked at this, and again, I know we discussed urban farming and some of the other things. My question, I believe, for either the attorneys or the assessor is that hang up that I understand from Lynn that it used to be that the county and the city boundary went right straight through his house, and so in order to clear that up, that we as a county asked that he deem that agricultural, that land. And so I want to help with some understanding of just, I think I hear the county saying, well, if it's just agricultural, doesn't qualify for urban or greenbelt because of production, but maybe if there's any context that could be given towards that question.
Yeah, I can speak to that briefly, Commissioner. So what the Community Development Department does is they look at zoning questions and what kinds of structures you can build. And so if they put that agricultural restriction, they're not saying that there's agricultural uses on the property for purposes of greenbelt. They're saying you can't live in a structure you build there. You can't make that you can't occupy it and make it your home on that property because it's restricted to only agricultural structures. And so it's really more of a question of what kinds of buildings and what kind of permits can be issued on that land rather than a question of does it have production to qualify for greenbelt. They're sort of fundamentally separate issues. So we would see that as an irrelevant fact that it's got a restriction to agricultural structures on that piece of land. The question that the assessor's office is looking at is, does this land have agricultural production? Does it have, and did it in the last 2 years have the sheep and have the, the kinds of production that would qualify with the AUMs to meet the requirements? And we don't see it as having that or having had that in the last 2 years. And in the future it may, and in the future it may be able to be applied for, but as of today and as of the last 2 years, we didn't see it. Does that answer the question?
Yeah, thanks, Ben.
My pleasure.
When's the last time there were sheep on it?
It would have been about 2 years ago. Once I started construction of that barn there, and it is called, in fact, a pole barn. Once the construction started on that barn, there was just no way Wayne or anybody else could have sheep there. Well, maybe there would be a way, but it just wasn't practical.
I think we talked, Lynn, that the Butlers have shown interest as well, that are just there to the north of you, maybe expanding some livestock into there, because I understand you're not wanting to purchase sheep, but hearing you say you'll welcome some of that, right?
Yes.
Commissioners, maybe I can just step in and maybe help direct some focus here. Not only are you looking for production, but you're also looking to waive the 5-acre requirement on this parcel. So the production questions are appropriate, but just this is hopefully to help the board. The explanation should also include how the production on this acreage is significant, maybe even to the point of being critical to the production on the larger acreage, which is the other qualifying parcel. So if that's not clear enough, the production on this parcel is not enough to get this in Greenbelt because it's too small.
Right.
In order to qualify, it's an exception to the acreage, and it has to be established how it's critical to the production on the larger parcel.
Which is why I asked if he had any structures on his other property that he stored stuff in.
Right. I just don't know why the sheep, I'm not sure how the sheep
Well, I'm just-
discussion's helping anything.
Well, because
I
I'm
guess,
seeing the bottom
personally.
part. Like the bottom part is critical. But does it matter then? I mean, if we feel that that is critical to his operation because implements left out in the elements degraded
Correct.
a significantly higher rate.
Yeah, I think that
right?
might be appropriate, but I don't see how the sheep discussion or the livestock discussion is helping.
But if we think that the barn is critical to his production because that's the only barn he has, then in your legal opinion,
I don't know that you
this
can get
qualify?
3 acres out of that, though.
that's what I'm saying. And that's why I'm at the bottom part I can get. The top part I'm having a hard time with. That's the only reason I brought up production.
Yeah, and
Does that make sense? Like I can see the bottom part being critical to his other operations.
if you can't park your tractor and things over there, maybe you need to park them here. I get that discussion, but
Right.
But yeah, we're talking.
And I got to that point.
Anyway, and I'm with you there. I just didn't know where the sheep
But that's why, it's because I
couldn't.
couldn't see how the top part was critical.
Right.
Yeah.
That's what I'm getting at.
Okay.
So the barn and the gravel around the barn is
What-
that thing
what
I
if-
actually see is critical.
What if we continue this to the next meeting and the bakers put sheep on it between now and then?
Well, again,
It has to be the last 2 years. That's the only
Well,
problem.
yeah, but it was only suspended for construction. It was only suspended for construction. If it was 2 years ago that there were sheep on it and it was suspended for construction, I'm willing to give that exception. But the construction's done now.
well, again, how is the sheep here critical
So that we
to
can
the farm
qualify
over
the
there?
upper part of the
The
piece.
sheep
Yeah.
were used for grazing, and one of the agricultural reasons, or one of the agricultural determinations from what I've read, is that ground can be used for grazing.
No, it can, but what do you do on the other farm? What do you do on the 11 acres? Is
Yes,
that what-
11 and a half acres. Right now, it's irrigated property. I've got hay planted in the entire in the entire
Yeah.
acreage.
And you've got your
So I
hog,
guess
yeah.
I guess my question here is
Well,
how
while the
is
hay
sheep,
is growing, how are you feeding the sheep?
how
Well, they're
is
on
the
this
sheep
property.
over here helping the hay grow over there?
Okay. Just because it was used for grazing.
Right.
Because while the hay's growing, where are the sheep eating?
Yeah.
I mean, that's the connection that I haven't seen made, and I'm just trying to help you focus
Okay.
the discussion.
I appreciate that. You're doing a fantastic job of helping us focus. And I mean, I'm willing to be creative, but I can only be so creative.
Yeah. Because we can't,
Connection between the two.
yeah, because the
Right.
backyard,
That-
yeah. 'cause
I
the-
see that on the bottom part.
The
Yeah.
grass that the sheep have been eating is on crested wheatgrass on the hillside there. In that lower portion there, outside of where my barn is, I hope to use that, that dry land pasture grass that's been recommended by IFA.
Yeah.
I'm trying not to let the fact that the dozer in the previous picture was not a high-rise dozer, meaning that it was not a cat dozer, influence my decision at all.
So you're looking to get an exception to the acreage requirement here, and to get an exception to the acreage requirement, you have to show how this property is used in a way that is critical to the operation on the other qualifying property.
Yes, and it is.
Not just that it's also in production. Like, if we got two things in production, that doesn't
Okay.
necessarily qualify the smaller acreage. You have to show that this acreage is so critical that without it, you couldn't produce on the other one. That's the kind of discussion
Okay.
that
And it
that
is
we should be
critical
having.
because I do park my equipment there. And as was mentioned, if that equipment's out in the elements,
Yeah.
it will deteriorate in a hurry.
Yeah.
You've seen the pictures, you've seen all of my equipment, to include my son's side-by-side and his kayaks. But you've seen the pictures of the equipment that I
In a
have.
flood year, they can kayak to the other
And,
property.
and
which we
I'm-
almost had.
this is a
That's what I'm
hobby
saying.
farm. I
This
don't
year,
have
that's feasible.
big equipment like JD Shepherd. What I have is I need to preserve it because I can't afford a $50,000 hay baler and a $100,000 tractor to pull it.
Yeah. That's where, again, we get back to what I said earlier. I can see the lower section with the barn and the access to that and the surrounding area. I can see that as directly in support of the 11 acres. Further down, because it's all open river bottoms land there. But the rest of it, I have a hard time with, particularly since it includes the backyard section and the back road there as well.
Did this used to be in Greenbelt?
No,
No, this is just
the-
a first-time application.
yeah, this has never been in Greenbelt.
Okay, I'm seeing the barn. I'm having a hard time seeing the rest.
Yeah, me too.
We know how much land that is.
It looks like less than an acre, I don't know. Around
The
that
barn with
barn,
ingress and egress is the bottom part, the non-slopey part.
to a butt up, maybe against that open piece.
Wanna-
to
we
the
could
right.
The blue line that goes around that, well, I've got 3.8 acres there that are in the county, which is not enough for me to build a home on. Not that I want to anyway, but there's 3.8 acres altogether. I think that's what the application says.
it did.
3.8.
Yep.
We could
3.81.
continue this to the next meeting, and in that time, we could come up with a ground area for the barn part.
That work, Diane?
I think one of the problems with that, again, this is Ben Stanley with the Attorney's Office. One of the problems with that is the application is for this parcel, right? You're looking at, is this parcel eligible for Greenbelt or not? And so in urban farming, we look at how much of a
Would we have
designated
to
area-
say the whole thing is or not?
Yeah, so it's
All
got to be the whole
right,
thing
so
or
you
not.
convinced me then it is, because we've got a barn on it.
But from our position,
Talk me
again,
into it.
it's a suspension of sheep for 2 years that is done at the decision of the landowner, and a property that is, where the landowners indicated there are other places to park that equipment, neighbors that could be used. We don't see it as properly in Greenbelt from the assessor's position.
Yeah. Just because his kid commandeered part of the space, I don't see that makes it any less critical, as long as his implements were still parked in there.
Yeah, what we're considering is the entirety at this point, and so we have to come back later and maybe look at carving out this section for another consideration.
Well, but what Ben's telling us is we can't carve part of it out. We either have to say this piece is critical to the other or it's not. And if that's the case, I'd be willing to entertain a motion. But
Okay, so to be sure then, we cannot carve this out, Ben, for later consideration?
I'm sure I could, please, go ahead, sir.
Well, I was just going to say, I don't see how that can be done. I mean, Greenbelt is different than urban farming. In urban farming, we have a subset of a parcel that
Correct.
can be in production. In Greenbelt, you're looking at the parcel. Is the parcel in production? If it's less than 5 acres, is it indispensable to some other production? And in this case, we would say, you know, a subset. Can you park your tractor on a 40-acre
No,
lot
I
and
get
call the
that.
40
I'm just
acres-
saying if it's possible to.
But if we combine the production of the two, doesn't meet the requirement.
We haven't had submission of any kind of evidence from the taxpayer of the AUMs on the other parcel that would justify it here. But from the assessor's office, we don't see that
Continue
as
it.
the,
We can
Right,
continue it or deny it and just come back as another time, but maybe we should just continue this if you think that would help
Whatever
the
you want.
discussion. What would you prefer, Lynn?
Well, just a couple of comments. With my packet, if you will, I've included the last 2 years of Schedule F, and I've never carved this out, if you will.
Yeah.
I've included that, so it.
So you did include your income from the farming.
Yes,
So production, in essence, was submitted.
yes. It's part of that packet that you should have that was supposed to be
Now that you say
forwarded to
that,
you.
that triggers
I've got
my-
copies of that.
Yeah, no, now that you say that, it's triggering my memory.
It's Schedule F, the last two years, 20 and 22. That was included, that was submitted initially. But like I say, I have not separated, I haven't kept track separately of the production here. Well, I really don't know how to document sheep eating grass on the hillside there. But yeah, it's all been combined and lumped together in the past. And it has been utilized the last more than 2 years. I have done that, and I submitted my profit and loss from farming the last 2 years. I submitted those with the packet.
Commissioner Gordon, are you still there?
Yes, I am.
Oh, I thought he dozed off.
I wondered for a minute too. That's why I asked.
I'm the reality is if we do, if it's an all or nothing situation, if we do say all and it gets appealed again, you know, then I'm reluctant to have that drug out, that process. I think that was where you were kind of going with that, Amelia. Am I correct
Yes.
that you were saying? Yeah.
Yep.
That yeah, we approve it, and then if it gets appealed, you let, you know. So that's the only question that I have. Is that the best thing to do right now, or continue it like Tom is perhaps suggesting, to where it might give us an opportunity to maybe carve out? Well, I guess that's somewhat off the table too, if the
Yeah.
discussion is an all or nothing. So if it is, as we see it, critical to the other piece, then, you know, I'm in favor of approving it as is.
Yeah, how far away again is this from your 11 acres? A quarter mile?
Quarter of a mile.
Quarter acre, quarter mile.
Quarter mile. And so the question would be, is it contiguous? And I don't know.
It's not contiguous. It's a quarter of a mile away, which is why they have to road their equipment there.
Right, exactly. You know what, I'm inclined to go ahead and approve this as a motion. And if it has to be appealed, then we can look at what the state says in return.
I'll second to that motion.
It's been moved and seconded that we approve. All in favor, say aye.
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 All right, that passes 3-0. We'll
Thanks,
see what
Lynn.
happens.
Thank you very much.
New
I
territory. This is the
appreciate your
first one
time.
of those that I've seen, so.
And tell your brother I don't try to be obnoxious, but
I'm learning, and Paul, thank you for helping inform us of the law as we go through this. You've got more experience than we do here, so
Just trying to help you
no
focus.
pun intended, but keep us corralled, so.
you're doing great. Always learn more.
Thank you for attending the flag retirement for that.
Oh,
There, both you and Commissioner Gordon were there. Thank you, appreciate your support. Thank you for your service to our country.
thank you. Thank you very much, Lynn.
Approve or deny application for review by the Board of Equalization of the Farmland Assessment Act for Robert and Suzanne Stevens.
Good afternoon again, Commissioners. And this last one of the day is appeal of a denial of greenbelt status for a number of parcels, some currently owned and some formerly owned by Robert and Suzanne Stevens. Some history on this series of parcels. The land was purchased and developed. They were rolled back from the greenbelt in 2019. And in 2019, the assessor's office rolled back the greenbelt, denied the application for continued greenbelt for lack of production. The applicant came to the Board of Equalization. The Board of Equalization reversed the assessor's office. It went to the State Tax Commission, who reversed the Board of Equalization and found that there was no production or not sufficient production. There was a State Tax Commission audit conducted from Brady Kelsey that concluded that there was not sufficient agricultural production. That has been appealed, is now still, I believe, pending in the district courts, as further appeals on that initial denial by the State Tax Commission for greenbelt status. Here we are again looking at some part of the subdivision where there's been 3 parcels, and the assessor's office, to make a long story short, in the interest of time, we'll just say the assessor's office still doesn't see the production. The audit has said that there wasn't the sufficient production. There is some argument here over classification of the land, whether it should be classified as irrigated or non-irrigated or non-productive. And so the taxpayer has fluctuated between arguments that, well, there was actually sufficient production, or maybe there wasn't production, but the land can't produce. They do have irrigation water rights as part of the development. Community development has required them to have water rights to be able to produce on that land, and we haven't seen the production. So you've got a number of photographs in your exhibit of what the land looks like, never any indicia of agricultural production, and so it has been denied its greenbelt status, and the assessor's office has been consistent in that position and joined by the State Tax Commission in that determination. So happy to answer any questions or get into this one with the taxpayer as we go through the whole process.
So what has changed since then?
You want to speak to that, Diane, about what has changed? We've seen very little change other than ownership has changed on some of these parcels. As the development progressed, some of the parcels were sold
Wanna
off.
Go through some of those photos.
Yeah, that would be great if you want to just highlight the
Yeah,
changes. I know
absolutely,
we've seen
Diane,
it
maybe you can
before.
talk through some of the.
I know we've seen it before. I just want to know what has changed.
Right off the bat, some of the things that have changed was the leveling and getting it ready to be a developmental lot so that it could be approved through the planning and zoning for a subdivision. I know there were requirements that they set forth. I know that they had to add soil along the road as like a shoulder of the road for people to get in and out if they purchased those properties. So, so this shows you, you can kind of see the line, the lot on the left has sparse weeds and grasses growing, and then the parcel on the right was recently laser leveled. You could just keep going through them. Just, so that's basically, the lot,
The good news is I see no noxious weeds on that.
yeah. The parcel numbers have changed from the parcel numbers that are on the appeal because the subdivision was approved, so now they're subdivision lot numbers. So it's kind of gets a little confusing when we're talking parcel numbers. But you can see that they were laser leveled. And the dates on that was in 2021, since I have to look at 2 years production. So I've been going out to these properties since 2019. I go out every couple of months to see what the production is and what has changed.
How many cars have we worn out because you're having to go check all these parcels?
Yeah. I get to learn a lot of the county. Yep, I get to see a lot of awesome farmland. And so those are, different months, but of the same year. And I know sometimes when I've been out there, right there, they were doing the wells. Also, one of the parcels on this appeal has sold and is no longer owned by the Stevens. So I want to note that as well. Okay, so, go back up. Okay, wait, stop right there. No, you can go, well, that parcel.
Ms. Garcia, can I just, do we know if the current owner has authorized
No,
this appeal?
no.
That might be something that needs to be addressed.
Okay, so go to the picture right before this one, Bert. Okay, so you see that? So that is not one of Mr. Stevens' parcels. That is Peter and Natasha Jordan's parcel that is a part of this, used to be Mr. Stevens, but once the Jordans purchased it, they actually got J.D. Shepherd farming that. He's the lessee. So there is production on other parcels, but not the ones that the Stevens owned. So I included those to show the difference between what is actually production and not. So if you go to the next one, then you can kind of see, because it's like towards the end of the lot, yeah. So you can see you can see the rows where it's been seeded and it's growing, and it's actually a 5-way. It's triticale and oats and barley. So anyway, so that is what real production looks like. Okay, keep going then.
It's a really cool picture of the rainstorm coming in too.
It's pretty cool. Okay, so this is another lot, another parcel that used to be owned by the Stevens, but that was sold. So this is the Schwartz's parcel, and Mr. Stevens mentions some things about this parcel that it shouldn't have been accepted into Greenbelt. But the minute the Schwartzes purchased it, they started farming it. And so they now have, she does cut flowers and she sells to florists up in Salt Lake. And I have visited her on many occasions. And that was when her greenhouse was just being built. And now her production is a lot more than this. So it obviously is in production compared to the other parcels out there. Okay, keep going,
They have
Bert.
an active income from it.
Yes, and they're expanding as they, the whole front, they,
Reasonable expectation of profit.
yes,
is,
and
think,
so
what we
I
would
get to
say.
learn a lot when I go out. When I go out and talk with people, I get to learn a lot. And so I learned something really cool from the Schwartzes, is that the whole front of the parcel, they grow sunflowers. They get a lot of people that want to do photos out there, but they don't like that. They don't want people traipsing through. But they actually harvest the sunflowers and use the oil it's a biodiesel, bio oil, and they run their tractors and all their vehicles with that. So
Wow.
it was kind of cool. Yeah, I
is
got to
kinda
learn
cool.
a lot. So that's what it looked like in 2021. Keep going.
That's
they
the last
have-
picture.
Oh, was that the last picture? Okay.
Yeah, that was the last picture.
Okay.
Oh, yeah, there's a second, yeah. There's a bunch of pictures. Sally had to break them up into different files. Because I have current ones of the Schwartzes.
All right. Let's see. Is it?
Okay, so these are the aerial photos showing what they look like from the aerial photography. So you could just keep scrolling through. So that half circle is one, and I did it for different years to show the possible changes. You can see the soil being built. So this one is the really alkali parcel, and it is like a half circle.
Bless you.
And it's my understanding that they were required by planning and zoning they've been dumping the soil there because they have to extend the shoulder out from the road. And that's a requirement for the subdivision. So that's why all that soil is there, is my understanding. And then that's a parcel. And see, it was laser leveled and cleared out. And that's what it looks like. And I did not include photos of the parcel that's no longer owned by them.
Okay.
So these are some more current ones. April 2023.
And then May.
That's the last one.
Okay. Any other questions for me, or?
I don't think so. Anything to hear, Mr. Stevens?
I'm Robert Stevens. Thank you for letting me speak. Where do I start? We can go through document by document if you like, and we can just go and talk about things informally if it's okay with you. Basically, what's happening here is these parcels, including the Schwartz's parcel, are all classified in the irrigation 4, or like 4 irrigated. Now, there's lots of land classifications, and this one really assumes that you have sufficient amount of water to irrigate, and you can grow something like alfalfa. We don't have any irrigation shares on these, and so your statement was actually incorrect, Mrs. Garcia. We own no irrigation shares on these. We built a canal through the property. If we were able to get irrigation water out to these lots, we would have, because it makes them more attractive, and that's what farmers want. We do have underground water rights, which means that you can use wells to go and sprinkle your grass or your forage or whatever you have. But they're not set up yet. We have wells. We don't have power to the property yet. We have power to the property, not to the wells. Not actually living there. I don't want to set up $50,000 sprinkling systems on each one of these lots. It's just, it isn't anything we want to do. So the issue really at hand is how should these parcels be classified? And I've been trying to get them reclassified now for about 4 years, and I've just been rejected every turn. Let me give you some history on this. It seems like in the 1960s, when this land was probably selling for a couple $100 an acre, Utah State sends some people out. They look at land in general, and for instance, in this big, huge area right here, if you could get your land irrigated, then you possibly you should be able to grow alfalfa in the irrigated 4 land classification. Our property was all at the end of the line, so there was a canal up until part of our property, and it just ended right there. It's because all the previous owners knew that you would not be able to flood irrigate these things. So as a software engineer who knew nothing about, farming for the last 20 years of my life, I've been trying to improve this stuff so I can get maximum agricultural production. Up until about 2018 or so, we would have ranchers in there who would just go and run their livestock and feed off the grass. And then we built the road. And so after it was laser leveled and sloped, and we got rid of all the debris that our neighbors had dumped on the property, we replanted grass on several occasions. And this is a risky thing. It's because you till in the fall and you plant your seed and you hope it grows in the spring, and then you hope that there's sufficient rainfall, because it is dry farmed, that it will take root and you'll have good agricultural production.
Do you feel that there was good rainfall this year?
No. Over the winter, however, there hasn't been enough to sustain the grass through the late spring and early summer. So yes, and so one of the documents I presented from the state website says 8 out of the last 10 years has been drought. There isn't anything about drought in the Farmland Assessment Act. And by the way, I've read that thing over and over and over and over again. There is a clause in there about, what's the exact wording, about no fault of the owner. I think in the 1960s, when this was all put together, it was to protect the farmer. It seems like now it's being used to actually weaponize by the assessors to go protect the state. Each of these lots have to be reviewed individually and not as the aggregate. So the assessor shows up in July, and remember, and so at the time, we had grass that was as tall as 8 feet high in some of the parcels. So they show up in July, it's all dried out. Our normal action is in the fall, Ted Allen shows up and he cuts the grass and he bales it and he hauls out the bales. So in July of 2019, when the assessor showed up, it was all dried, it looked awful, but a month or two after that, Ted Allen shows up and he cuts all the grass and he bales it, and we sent Diane photos of the bales and we accounted for them and so forth. So this has been happening year after year after year. Every single year, he shows up in the fall, he cuts the grass and he bales it, and I send her photos, and every single year she says, there's no agricultural production on your property. This year, Ted Allen showed up a month ago, and he cut and baled from grass on one of the lots. It was a lot that I'd recently sold, and the bales are still there. And I noticed as you were flipping through the sides, here's some of the bales. On that lot right now, there's like 5 to 7 of the bales, and they're big bales. And this is what you get usually in the fall. So one, here's some of the problems, and I'm here not just because of myself, it's because I see some serious issues that I think need some discussion. One, the FAA land classification system is not easy to go and classify your lot in. Secondly, as far as I can tell, there is nobody who I can, as a citizen or farmer, approach and say, please help me classify my land as it should be. I've asked the assessor's office, and they don't have anyone. I've called the state, and I've called universities, and I can't find anyone who knows how to go and visit a property and classify a parcel as it should be. Next, the approach here in the county has been, is there signs of agricultural production or not? However, the law states that is there agricultural production that meets how the land is classified? If it's classified such, I should have alfalfa every single year. If I can't produce that much, either it's actually misclassified or something else happened. So this is really what it is. In terms of the Schwartz stuff, that's just big. I mean, that's just mind-boggling there. It's because the same rancher who did all of our property for all those years, he was also the rancher on the Schwartz's property, and nothing was different. She had no irrigation, same rancher, same grass, everything, and Diane approved her parcel and rejected ours, and that was vital information that should have been presented to the court. Recently, I just had a lawsuit, and we overturned a settlement agreement just because a vital piece of information was actually withheld from the court. So our discussion over the hearing, all these hearings should have been very different if we knew that the Schwartz's land was classified in the same way as all of my land, and it was the same rancher, and nothing was different. She had no more water or anything like that, just that Diane approved hers and not ours. And so I feel like I'm a target of this whole thing, and it's just really wrong. So one, you need to get somebody here in the county who can classify parcels. I've heard the argument, well, it's better if it's classified at a higher land classification, because if you sell your land, you don't have to pay as much in rollback. However, if it's classified at a higher land classification, it weaponizes or enables the assessor to actually say you're not meeting agricultural production for the level of land classification. Excuse me, I stutter and my mouth is dry, so it's like the worst of both worlds. Okay, that would be great. So my goal here today is one, we need to have a discussion on how we can look at parcels individually and not in the aggregate for an entire area, and say what are the factors that will help us go and classify this land right. Some of the factors include the soil itself, salinity of the soil. I submitted some documents from Brigham Young University who tested our soil, and it's extremely high in salinity, such that alfalfa should not work there anyway. Some of the photos you saw of that big half-moon-shaped lot, after sloping, laser leveling it, and replanting the seed on several falls over the past a few years. This spring, the water had seeped up, and the soil, and the soil had seeped up, and all the grass that we had planted in the past had died. So obviously there's going to be anomaly situations of anomaly years, and that shows you that like that parcel should be either classified as non-production or some low sort of production level. I also did some investigative work. I wanted to see how the parcels are classified of my neighbors. and some of them are meadow, and some of them are graze. Anyway, I think overall I've covered everything. Do you have any questions for me?
I don't think I do.
No, just that the state statute is that requirement that it has some production over the
Yeah.
previous 2 years.
Yeah,
And if it has a history of non-production particularly, it just kind of compounds the need that perhaps we cannot have a farmland assessed for that land, whatever land it
Right.
might be. So if it's historically unable to produce agricultural products, either grazing or cattle living and a cattle farm type of thing. If it can't raise crops, then it may not. We can't assess it as farmland, I don't think.
yeah. So I have had production every single year. It's just that it's not what they want to see. So they want to see either flood irrigation and it's nice and green and it's growing alfalfa, or they want to see it fenced and there's animals that are grazing. And in this kind of situation, you would have to import bales. So my argument is, if it's a dry farm lot and I am growing grass and it's mowed and baled every year, then that is farm agricultural production. And that's what we've done every year. So to go show up in July and lean parcels is really weaponization of government. I mean, that is completely wrong. And that's what happened, and that's what we've had to suffer now for the last 3.5 years as we've gone through hearing after hearing, and compiling all these documents and stressing all the time, and it just shouldn't be.
But the state tax commission overturned the appeal last year, right?
It's still in flux, and so the final thing was, it turned out she had taken a bunch of photos of parcels that weren't mine. She had submitted false evidence. She didn't include the Farmland Assessment Act application of the Schwartzes, on and on. And the state had given me a date where I can appeal. I received the notice after the expiration. So I phoned them up and I emailed them and I said, what should I do? And they said, well, just go and create your appeal. And I worked on it for like a week or two. I sent it in and they denied me. It turned out they had used their own stamper for the postage envelope. And so they can go and stamp it any date they want, have it sit in the back of someone's automobile, and mail it out anytime they want. So now I have a motion in there to have a judge review them using their own postage stamper. You and I would just go and visit a post office, and have it all officially all done, and they can just go and stamp it and have it sit in the back of their cars. So it's still in flux. I still may win this, but in the meantime, I had paid a greenback rollback on all these lots because we had subdivision approval in February. So the issue that I'm standing for you right now is one, I'd like you to start having a discussion about who can go and classify lands appropriately. And two, when you hold these hearings, you really have to hold them not according to if you see agricultural production or not. You need to go and hold it according to how the land is classified. So there are like AUMs, and there are, on these lots, at the way it's classified right now, I would have to add up all the bales of hay and see if I met the requirements. If I didn't, then, well, it is what it is, and these are dry farms, and I've done all I can do right now. And so sometimes, these things have lots of agricultural production, and sometimes they have none, or very little, and drought is the cause usually.
Well, and I think and I understand that, but it is frustrating that they do set production requirements, and we have to meet the production requirements.
Yeah, as they're classified.
Yeah.
Yeah, and so I'm saying this is all misclassified. Some years, if it's really, really wet all winter long, and then all into the spring, I'll have lots of grass. And then if it's drought, I won't. So that's the issue.
Okay. But we have submitted production to the state, and the state did overturn last year, right?
Yes. If I could speak to a couple of
Yeah.
things real quickly. First, just for the benefit of the record, I wanted to make it clear that we take exception to any allegation that there's been false evidence submitted or that we have weaponized any bit of the code against any individual taxpayer. That's not the goal of the assessor's office.
That's
I
fair.
documented all that stuff in my motion.
It's a fair statement.
We are willing to look at evidence of all sorts. Taxpayers and property owners can provide invoices and receipts and documentation that shows what was produced when the assessor wasn't there. The tax commission did look at all of the evidence that was provided, had an auditor visit this property, said that it did not meet, looked at questions of classification, said it did not meet the production requirements, it was not eligible for Greenbelt. So the position of the assessor's office is that we ought to affirm that position of the tax commission. And again, this year, it has not had the 2 years required production. It hasn't met the AUMs needed.
And the state statute, the code that's run by the legislator and signed off by the governors past decades, we have to comply with those. So we have to follow that statute.
So my reply is it has met agricultural production for the last 2 years. However, I'm not sure if it met it according to the level of how it's classified. Our rancher's been out there every single fall. He's mowed and he's baled the grass and he's hauled them away, and that is agricultural production. You don't see it until the fall, usually, and then you see it.
Do you have receipts for how many bales and what the value was?
I do, and I've sent her.
Yeah.
her
And we
photos
submitted
and
those,
emails every
those were
single year.
submitted to the state tax
Yeah.
commission, right? Yeah.
So
And
this hearing now is not about 2019 or 20, it's about 2022 and 2021. It's because I reapplied for the FAA application, and so I have to show 2 years of agricultural production in the past, and I've sent her the photos every year, and I sent her emails and so forth, and it just gets all ignored. So
Yeah.
that's my argument.
Anything from Brandon?
Commissioner Gordon?
Yeah, I think, from a land, like having someone classify land, I look at that like it would be an additional heavy lift for an already taxed assessor's office that I believe does a very good job. And from like our perspective, typically it's the landowner that invites, the change, if you will. So if we were going to make a change on our farm, we would, like we did last week, come in to the development office and ask for that. So in order to try and have someone solely, I don't think that I'm in favor of, hiring more people and raising taxes to be able to do that. And so I just want to clarify that statement. I know that's not what we're here to do, but along with that, I think with the recommendation of the assessor's office, I'm leaning that way on this one.
Yeah.
Yeah, I think if we do anything else, it'll be appealed and overturned anyway, and I think that's a waste of everybody's time and money.
So who's going to classify the land then? Who's going to do that? It's part of your job. And so what's your background that you can do that? And then how should my land be classified since it doesn't have any irrigation water? It has no ditch.
I think we don't need to,
Yeah,
we've already had some back and
Okay.
forth and some accusation here and I think the process is to apply and look at that application, but that's a separate process than
Okay.
this. But we have to rule based off of what the state tax law says and what
Right.
their production says.
Right.
And in the past, attempted to overturn that, and they've overturned it. And so it would be a poor use of taxpayer resources for us to do what we did last year and expect different results, right? I think that's the definition of insanity, is to do the same thing over and expect different results. And like I said, I think if without a change of classification, and maybe we can appeal that, but that is a separate process.
Yeah.
Well, it's what is the process? It's because I haven't been notified of the process. I've been denied every single time I've approached it.
I don't know the details on the process of changing classification. Do you, Ben?
That is something that the farmland assessment analyst for the county can do, so maybe Diane wants to speak to that, but he could apply to the county assessor's office for a change in classification.
There's not even a form at her office to do this.
So I have explained to both Mr. Stevens and his wife Suzanne that if the parcel is not currently on Greenbelt, and these parcels are not currently on Greenbelt, then we don't worry about the land classification because they're not on Greenbelt. So when they apply, then we look at that, and even though there are parcels in that area that are different classifications than Mr. Stevens' parcels, there are also quite a few parcels that are higher level classifications than his. So there's a whole, it's slope of the land, depth of the soil, alkalinity, there's all sorts of different things. And in the state hearing, we went through what those classification requirements are. So irrigated 4 is the lowest quality irrigated land. So my understanding from planning and zoning, Mr. Stevens had to provide so much water for culinary for his subdivision and so much water for crop irrigation or agricultural irrigation. So it does have irrigation water, which is one of the requirements for it to be classified as irrigated land. It is the lowest irrigated land possible. So, And
that was reviewed in the appeal with the State Tax Commission?
The State Tax Commission just went through what production, if it met the production requirements or not. But he did present all that information, and they did not address or change his land classification. So we can have one parcel that has 3 different classifications, because it could have a steep slope, it could have a pond on it that is non-productive. You can get different classifications all on one parcel. So it's based on the criteria that the state has set, and that criteria shows it not only shows what the land attributes are, but it shows what the management and practices need to be to make that land produce something. Right. So you can say, well, I have crappy farmland, so therefore I can't produce anything. Well, farmers don't do that. They say, what do I need to drain off? What do I need to add? What do I need to amend the soil? What do I need to do to make this land work for me? And so that's what the land classification definitions are outlined by the State Tax Commission. So it's the assessor's stance that these parcels still meet that requirement and meet all the land classification definitions for irrigated 4.
Yeah.
I'd like to say too, I could bring all my neighbors in here, all the people who have ever farmed our property, and they will tell you that is completely wrong. And there's no way this should be agricultural number 4. It has no irrigation water. It's got some underground water rights now, just because I bought them and had them transferred onto the property. It's just way too salty. And how am I going to amend the soil so I can have alfalfa? I mean, that's just ridiculous.
Yeah, that's why last year when the state reviewed it and denied it, then we're continuing that same discussion now.
Yeah, you can do that. However, when I'm asking you not to do her opinion versus my opinion, let's get some people who really know what they're talking about and look at the land and the soil type itself and the irrigation or lack of irrigation and say, what classification should this be? And why are my neighbors in meadow and grazing? And by the way, there is no one in a higher land classification around me. I've done a study of all the parcels around me. I've submitted that as evidence. So let's get some people who really know what they're talking about out here.
Yeah, but for now, we have to look at these specific parcels and whether they meet the Farmland Assessment Act status at this point.
For agriculture number
Right.
4 in the last 2
Right.
years, they haven't.
Right, and so for me at
Yeah.
least, I think we should go ahead and deny the application just based
Okay.
on this alone, not the neighboring lands, because we're only looking at these specific parcels.
All right, was
Okay.
that a motion? That was a motion.
Second.
Okay, however, I just want to point out, in 2 years from now, if I apply again, she's going to say, well, your land was classified in the agricultural 4, and you still weren't able to have alfalfa there in the last 2 years. And so and so it's just like endless cycle, and it never gets fixed.
Yeah, it may be land that can't be. I don't know.
Yeah.
I don't know.
I'm not sure either. Yeah.
Thank
It's
you.
been moved and seconded. All in favor?
Okay, thank
Say
you.
aye,
Aye.
and that's to deny.
Aye.
To deny. Yep.
Deny.
All right, that is the last item on our agenda. Do I have a final motion?
I'll make a motion to adjourn.
Motion to adjourn.
Oh,
we-
moved and seconded. All in favor, say aye. Aye.
Aye.
All right, we're
Aye.
adjourned.
Goodbye.
Hey, how are you? Good. Did you watch all this? They're always so hard. 'Cause, you know, but
Oh. I don't need it. That's very kind.